how can you prevent your intellectual property rights being infringed? Well, there are two main ways you can do this. Firstly, you need to protect your intellectual property. And secondly, you need to make sure that you are the owner of all intellectual property rights that are related to your business or your organisation. When protecting your IP, it's really important that anything that can be registered is registered. So for example, your trademark, your registered design rights, and any patents if you have an invention or an innovative process. You should also look at your brand or your logo or whatever it is, your product in the round, and consider if multiple intellectual property rights can be protected for that one item. So for example, the logo could be protected as a trademark. The design of the bottle, for example, could be a registered design. And if there's a unique function to that design, you could also consider seeking patent protection. In relation to your non-registrable IP, the thing that you need to do, so that's copyright and unregistered design rights, is to make sure you have a really thorough log from the creation initially to the stage you're at any point in time. So making a note of revisions, the date the document or product or whatever it is was modified, who was the creator, and anyone that affected subsequent modifications or changes. And it might seem like a lot of effort to do, but it's really important for keeping an accurate record of who owns what and how long you've had the copyright in a particular item. The most important way, though, in which you can protect your IP, and it should be at the fore of your mind when you're starting out and throughout the life of your organisation, is that IP does not protect ideas. So if you have any design ideas, any formula ideas, a great new invention or an innovative step that you want to protect, as soon as you tell somebody, you potentially lose that protection. So it's really important that if you do need to disclose this information, for example, to a manufacturer or a potential business partner, you are getting that person to sign a non-disclosure agreement, so a confidentiality agreement, before you tell them the information. And you can see a lawyer who can help you draft up a precedent agreement, and then you can just update that every time you need to reflect the information you're disclosing. The second way that you can reduce the risk that somebody accuses you of infringing their intellectual property rights is to make sure that you are the owner of all intellectual property. It might sound really obvious, but actually there are situations in which things can fall through the gaps and copyright can belong to somebody other than you or your organisation. So the general position, if we take something like copyright, for example, is that the author or the creator of the original work owns the copyright in it. There's a few exceptions to that, one of which is employees of a company don't own the copyright, the company owns it. But generally, the premise is that copyright exists for the original creator or author. So that might mean, let's say you're starting up from scratch, you haven't got much ready cash, you ask your friend to take some photographs of a new product, for example, let's say it's a new sports watch, and your friend takes these pictures and you put them on your website and you think that that's fine, but actually your friend owns the copyright in those photographs that he or she has taken. Similarly, let's say you've got a new product or a brand launch and you want a small promotional film to promote that, and you engage and you pay for the independent services of a film crew. Actually, again, the copyright of the film exists and belongs to them, at least initially. And so while in the early stages this doesn't seem like a big problem, if you become very profitable or very famous, there's a real risk that you would have people turning up and saying, actually, I own the copyright in that photograph or in that film, and that's not what you need. So the thing that you should try and get into the habit of doing is, like with the non-disclosure agreements for confidential information, is to ask people to assign the copyright to you via an assignment agreement. It's a very short contract, and again, you can ask a lawyer to draft you up a precedent, and it just says that the person assigns to you the copyright in anything they create for you immediately upon creation. The only thing that you need to be aware of is that for it to be a valid assignment, a valid contract, you need to provide something of value to that person. So if you're paying them anyway, that's fine. But if it's a friend, for example, or a volunteer, you need to make sure there's some valuable transfer from you to that person, albeit £1. You need to make sure that happens. And again, speak to a lawyer if you're not sure about that. And it's just a good practice to get into. If you're in a position where you think, looking back, actually, we had an independent person create our logo, or my friend did the website for us, you can retrospectively ask for an assignment of the copyright back to you. Again, you just need to make sure that there's some valuable consideration being transferred over to that person.